Hello. Hi. Happy hump day. It's hump day. Hello. Hello. Can you guys see me? Can you hear me? What's up? I see Debbie, Brady, Johnny, beautiful Sarah, Mo, Juicer, Cole. I'm glad you made it. And Danielle. Hey, Danielle. Good to see you. It's been a minute. Can you guys see me and hear me? Give me the heads up that we are good to go. Today's a document day. We're going to be reviewing quite a few documents, but we'll get through them pretty quick. We're going to review the Drake controversy, and as of right now, filed, let me pull it up. I think just a couple minutes ago, Diddy got denied bail once again. Denied. I'll review the document. I just saw it as I was coming live, and it says that no condition or combination of conditions will reasonably assure the safety of the community. So there you have it. He was denied this third time around. I will play it. I'm sorry, I will read it. I'm being distracted by the comments. I will read it after I'm done with the Drake documents. Hi, Sarah. Good, I'm glad you guys can see me. Okay, so Diddy denied bond for the third time. We're going to start reading with the Drake documents. If you don't know about Drake and Kendrick Lamar, they have been in a rap feud. To be honest, I don't know a lot about the details, but I do know that the main points of it all. I know that Kendrick Lamar in Not Like Us in his rap song made accusations of Drake being a PDF file, if you know what I mean. And so Drake has come up with petitions and what I would say a lawsuit, essentially, to basically get information. It's a petition. So with that being said, he's claiming that UMG and Spotify are conspiring against him with Kendrick Lamar content, and they are doing, corruption of payola and bots. So we're gonna read. Hello, Cynical. Good to see you. We're gonna read through the documents. We always read documents here on my page. So hi, welcome if you're new. My name is Melly. We cover true crime, legal documents, entertainment, all of the above. So Diddy just got denied bail. We're gonna see that document as well. They're fairly short, and I kind of try to go around the fluff, but I do want to read an article by Billboard. So I'm going to share it on my screen, and we'll read that before I get started on the legal document. So for those of you who don't know about the Drake and Kendrick Lamar situation, this will help. It states, Drake accuses UMGM and Spotify of a scheme to artificially inflate Kendrick Lamar Not Like Us. In a legal petition, the Starz company accuses UMG of serious wrongdoing, a stunning twist months after his high-profile feud with Kendrick. And if you don't know, UMG owns Interscope Records and Republic Records. And so if I'm correct, I'm looking at my notes. If I am correct, Kendrick is with Interscope and Drake is with Republic. And so they're all under the same kind of umbrella. And if you haven't heard Not Like Us, like I said, he claims that Drake is a PDF file amongst many other things. In my opinion, Not Like Us is very controversial, but I found Meet the Grams just as controversial. So I am somewhat involved in the hip hop community. I mod for a big channel that has rap battles. He's very well known, Rare Breed. So I kind of hear a lot from there, but we're going to read this article by Billboard, and then I'll get into the legal documents. Hey, PZ, good to see you. I have Nightbot too. So mods, I appreciate you for being here, and let me know if Nightbot gets a little crazy. Because I'll cancel Nightbot. But anyways, let's get started on the Billboard. I'm just going to read a little bit of this, and then we'll hop on to the legal documents. So it says, Drake has initiated legal legal action against UMG, Universal Music Group, and Spotify over allegations that the two companies conspired to artificially inflate the popularity of Kendrick Lamar, Not Like Us. In a filing on Monday, November 25th in a Manhattan court, Drake's Frozen Moments LLC accuses UMG of launching an illegal scheme involving bots, payola, and other methods to pump up Lamar's song, a track that savagely attacked Drake amid an ongoing feud between the two stars. UMG did not rely on a chance or even ordinary business practices, attorneys for Drake's company right. It instead launched a campaign to manipulate, saturate the streaming services in the airwaves. Drake's attorney accuses UMG of violating the Racketeer-Influenced Corrupt Organizations Act, the federal RICO statute often used in criminal cases against organized crime. They also allege deceptive business practices and false advertising under the New York state law. No comment. The court filings are a remarkable twist in a high-profile beef between the two stars, which Drake and Lamar exchanged stinging diss tracks over a period of months earlier this year. That such a dispute would spill into business litigation seemed almost unthinkable in the world of hip-hop. I beg to differ on that. I feel like we've seen this before with 𝗍𝗍. No? I don't know. Let me know. I'm not a professional in the hip-hop industry, so... Nonetheless, it also represents a stunning rift between Drake and UMG, where the star has spent his entire career. First through signing a deal with Lil Wayne's Young Money imprint, which was distributed by Republic Records, then by signing directly to Republic. Lamar, meanwhile, has also spent his entire career associated with UMG, first through the TD imprint, which was distributed by Interscope, and more recently through his own company, PP Lang, which he licenses through Interscope. In technical terms, Monday's filing is not a full lawsuit, but so-called a pre-action petition, which is a procedure under New York law that aims to secure information before filing a lawsuit. Parties named in such petitions will not necessarily be targeted in the eventual lawsuit, and the allegations in Monday's filing seem squarely aimed at UMG than Spotify. In a statement to Billboard, a UMG spokesperson sharply denied Drake's allegation. Quote unquote, the suggestion that UMG would do anything to undermine any of its artists is offensive and untrue. We employ the highest ethical practices in our marketing and promotional campaigns. No amount of contrived, absurd legal arguments in this pre-action submission can mask the fact that fans chose the music they want to hear. Spotify declined to comment on the allegations when reached by Billboard. Drake's attorneys claim that UMG carried out its scheme in a variety of ways, including by charging Spotify vastly reduced licensing rates in exchange for the streamer recommending the song to the users who search for the unrelated song and artist. They also claim UMG paid influencers to boost the song on social media and also hired armies of bots to fraudulently spike the numbers. Quote unquote, UMG conspired and paid currently unknown parties to use bots to artificially inflate the spread of quote unquote, Not Like Us, which is Kendrick Lamar's song, and deceive consumers into believing the song was more popular than it was when in reality, Drake's lawyers write. In one particular eye-catching claim, the petition claims that UMG paid Apple to have its voice assistant feature Siri purposely misdirect users to Kendrick's song. Online sources report that when users asked Siri to play the album Certified Lover Boy by Drake, Siri instead played Not Like Us, which contains the lyric certified PDF file, an allegation against Drake. Apple's not named as a respondent in the petition, nor accused of any legal wrongdoing. A spokesperson for the company did not immediately return a request for comment. Why would UMG choose to aggressively boost Lamar's song? Drake's lawyers say it was partially because of the internal corporate dynamics at UMG and Interscope, where financial incentives for executives are largely based on the specific UMG division, rather than the performance of UMG more generally. So instead, Drake has repeatedly sought to engage UMG in discussions to resolve the ongoing harm he has suffered as a result of UMG's actions. The petition reads, UMG refused to engage in negotiations and insisted that UMG is not responsible for its own actions. Instead, Drake says UMG has pointed the finger at Lamar and insisted that Drake should sue his rival rather than the label. He also claims that UMG told him that the label would sue Lamar if Drake ended up filing his own lawsuit. So that was like a precursor for you guys that are not familiar with the case. I saw the cynical one. Hello. Thank you for being here. Augie, you made it. My beautiful Augie. I'm so happy you're here. And beautiful 𝐴𝐵. I saw Biggs in here, Big Girl for Life. Why is 𝗏𝗏𝗃 going crazy? Let me pull up I'm going to pull up the actual legal document for this Drake thing, and then we'll go from there. Sorry, let me pull it up. There's quite a few documents. And by the way, Diddy did not get bail. I just heard about that. So that being said, I'm happy about it. I feel like I was fearing for the victims here with this whole Diddy situation. Nonetheless, he did not get bail. We'll be reviewing that document. I just saw it as I came on here. I was uploading the information and I saw it, so he didn't get bail. Of course not, right? Right. Thank you, Shadow Dragon. Oh, I appreciate you. Shout out to you. Love, showing you lots of love, and you showing me love. Likewise, I appreciate you, friend. Oh, I appreciate you, Shadow Dragon. He just gifted 5 memberships. Shout out to Shadow Dragon, good friend of the channel. And welcome to everyone that became a new member. Let me just make some adjustments. This is why I don't do replay live chats. But Shadow Dragon, I appreciate you so much. Love, shout out to you. Let's get started. So this was filed on 11/25, Frozen Moments, which is Drake's LLC against UMG. Verified petition. It says, petition of Frozen Moments by and through its undersigned attorneys respectfully petition the courts in New York City practice law for an arguing granted limited pre-action disclosure from respondents UMG and Spotify. Nature of the dispute. Let me make sure you guys can see that. Cool. All this information, by the way, I'm not a legal lawyer. I'm not a lawyer. We're just reviewing the documents. And that's it. These are the legal documents out for the public. So let's get started. Number 1, in his memo to staff reflecting on highlights of 2021, the CEO of UMG, 𝐿𝐿𝐴𝐻, remarked on it being harder than ever for artists to break through the noise. 60,000 songs are added to Spotify every day. Pause. If you know about 𝐿𝐿A𝐻, you know. If you don't, you will know soon. We're going to be covering some of that here on my channel, maybe throughout the weekend. Diddy related? I don't know. Spotify is the world's most popular auto streaming subscription service. As the end of the third quarter of 2024, Spotify boosted more than 640 million monthly active users and 252 million subscribers. Spotify pays music companies like UMG for the right to license songs so it can play them on its streaming and subscription platforms. In 2023 alone, Spotify paid more than $9 billion in royalties to music labels and producers. Hip hop is one of the most popular genres on Spotify, amounting to nearly a quarter of all streams on Spotify globally in 2023. So we know that hip hop is one of the most popular genres and it's making a lot of money. And I'm just wondering personally, a Melly question is, do the artists make as much money as these label companies and producers are making? Question mark. Something to think about. Number 3, Spotify and UMG have a long-standing symbiotic business relationship. Symbiotic meaning that they work in tandem together to basically essentially work around each other's business to make sure that it works. That's what symbiotic means, which is an important term if you didn't catch that. As one of Spotify's earlier supporters, UMG entered into a multi-year global license agreement with Spotify in 2020. UMG and Spotify collaborate on strategic marketing campaigns and products, and in 2024 announced an expansion of their strategic partnership through which Spotify will, quote unquote, amplify music discovery and social interaction and enhance fans' experiences across the platform for UMG's family of artists and songwriters. Based on UMG's final reporting, Spotify paid UMG around $2.28 billion in 2023, which amounted to 20% of UMG's total revenues in 2023. Now, that's a shit ton of money, if you ask me. 20%, that's a lot. And my question is, are there other record labels who kind of fall under the similar model? I don't know. Are these questions people are asking themselves? as this rap feud entails? Just curious. These are just questions that like pop into my mind. Let me move on. Streaming is an essential to UMG's current bottom line and its future business strategy. In a report related to third quarter of 2024, UMG noted a nearly 29% over-year decrease in downloads and other digital revenue because of the continued format shift towards streaming across the music industry. UMG's long-term strategy relies on accelerating the growth of and monetization from streaming and subscription. In October 2024, UMG unveiled a new slogan, quote unquote, streaming 2.0, which illustrates the importance of UMG places on saturating the streaming market. In 2024, UMG did not rely on a chance or even ordinary business practices to break through the noise on Spotify and likely other music platforms. It instead launched a campaign to manipulate and saturate the streaming services and airwaves with a song, quote unquote, Not Like Us, in order to make the song go viral, including using bots and pay-to-play agreements. So, like I said, Not Like Us is by Kendrick Lamar, and he basically claims in that song that Drake and people in his circle are certified PDF files. If you don't know what PDF files means, I'll type it in the chat, but I'm sure most of you know. And like I said, for me, yeah, Not Like Us was a lot of controversy, but also I thought Meet the Grams was pretty damaging as well. So with that said, I am not a bot. So I do listen to Kendrick Lamar, Not Like Him. So I'm not a bot. No. I'm just messing with you guys. I'm being a smart ass. But anyways, Drake, I do not appreciate you saying I'm a bot. No. Moving on. I do really have to say I am really into Drake's new album. Kendrick's new album, GNX, I believe it's called. Really into it. So if you guys haven't listened, go stream that. Moving on, number 6. UMG released Not Like Us on May 4th, 2024, pursuant to various contractual rights, and has excessive control over licensing of the song. On information and belief, UMG charged Spotify licensing rates 30% lower than its usual licensing rates for Not Like Us in exchange for Spotify affirmatively recommending the songs to users who are searching for other unrelated songs and artists. Neither UMG nor Spotify disclosed that Spotify had received compensation of any kind in exchange for recommending the song. On information and belief, Spotify pays UMG licensing fees through wires or mails. Or mails, exactly. So basically what they said there is that if you searched for the song, Drake's song, Certified Lover Boy, you would get Kendrick Lamar song. I did do it a couple of days ago. I'll have to see if it's still the same. But it does come up. You get like an album, artist. The way it comes up is rather interesting. I'm not sure if that has changed in the last few days. So check for yourself. But again, we know what we stream as consumers of the hip hop industry, right? And I think that although people find that Drake filing these petitions and lawsuits is rather petty, I feel like if he is willing to go against the bigwigs, there's ulterior motives and things beneath the curtains, if you know what I'm saying. I feel like if you're willing to go up such big companies and create all of this controversy, there's other stuff, right? Which maybe will come out. I'm not sure. That's just my opinion, allegedly. My opinion. I'm not a professional. Nonetheless, let's move on. UMG, directly or through Interscope, also conspired with and paid currently unknown parties to use bots to artificially inflate the spread of quote unquote Not Like Us and deceive consumers into believing the song was more popular than it was in reality. Bots are software programs designed to mimic human behavior to appeal to be real in social media accounts. One individual known to petitioner revealed publicly on a popular podcast that Mr. Kendrick Lamar, Duckworth label, Interscope, paid him via third parties to use bots to achieve 30 million streams on Spotify in the first days of the release of Not Like Us, with the goal of jumpstarting the song's spread and turning it into a crazy hit on the platform. The whistleblower describes Spotify as the easiest platform, quote unquote, to bot because it does not, like other streaming platforms, have certain certain security measures when it comes to a bot protection. The whistleblower further revealed that on May 6, 2024, an individual affiliated with Interscope sent him a payment of $2,500 via the digital payment platform Zelle, which is owned by a number of banks, and that he was promised another $2,500 and a percentage of the song's total sales for his initial push. On information and belief, UMG hired other unknown third parties to use bots to promote Not Like Us and also to inflate the streams of Not Like Us music video, which UMG first published on July 4th, 2024. UMG appears to have used similar tactics with other streaming services. On information and belief, UMG paid or approved payments to Apple Inc. to have its voice-activated digital assistant Siri purposely misdirect users to Not Like Us. Not my Siri going off on my phone. Literally, she's like, what? What you say, Melly? Online sources reported that when users asked Siri to play the album Certified Lover Boy by recording artist Aubrey Drake Graham, Siri instead played Not Like Us, which contains the lyrics Certified PDF file and allegations against Drake. Ooh, YouTube got me on my best behavior here. Are you guys catching on? It is a hit though, right? 𝐁𝐿𝐿, you're a professional though. Try to be. I know how to put it. Yes, Augie, we missed you. Hi, Sarah, I love you. Thank you for being here. Life artist. It's on the radio here a lot in Vegas. Absolutely. It has like 180 million views when I just looked on my way home. So with that being said, I'm not a bot. I did listen. So Drake's accusation falls rather short. Moving on. UMG engaged in similar pay-to-play schemes to increase the airplay of Not Like Us on the radio. Pay-to-play as in payola. Petitioner has obtained information from a third party indicating that at least one UMG employee made payments to an independent radio promoter serving as an intermediary who agreed to transfer those payments to certain radio stations and or radio station employees. These radio stations subsequently played Not Like Us without disclosing that they had been paid to do so. This practice, known as payola, is prohibited by the Communications Act of 1934 and has been the subject of regulatory scrutiny by a number of executive agencies. In 2006, UMG agreed to pay $12 million in a settlement with New York Attorney General following an investigation involving accusations that UMG executives had used a broad array of pay-to-play tactics to secure radio airplay for music. In connection with UMG's settlement, then New York Attorney General Eli Spitzer explained, quote unquote, consumers have a right not to be misled about the way in which the music they hear on the radio is selected. He continued to say that pay-for-play makes a mockery of claims that only the best or most popular music is broadcast. Separately, in 2005, UMG was sued by two radio promotion companies alleging fraudulent pay-to-play practices. Number 12. While historically payola has been thought of in terms of paying radio stations to play songs, in February of 2020, the Federal Trade Commission released guidance stating that by paying an influencer to pretend that their endorsement or review is untainted by a financial relationship, that is illegal payola. On information and belief, UMG employed a similar scheme by paying social media influencers to promote and endorse the song and video. For example, petitioner stands that UMG paid the popular NFR podcast, which has nearly 300,000 subscribers on YouTube and over 330,000 followers on X, to promote Not Like Us and its video without disclosing the payment. As part of its deal with UMG, the NFR podcast published podcast episodes, tweets, and other content publicly about the song. And in sea change for UMG's internal policy, UMG removed the song's copyright restrictions on YouTube and Twitch, thereby whitelisting the song, which further incentivized influencers to spread the song. UMG's scheme to ensure Not Like Us broke through on Spotify and worked. Not Like Us broke Spotify records, as Interscope posted on its X account. And then here's an image, if you guys can see, of the tweet. The NFR podcast states, Kendrick Lamar Not Like Us becomes the fastest rap song to reach 300 million Spotify stream. It only took 35 days. In my opinion, Millie's opinion, I don't think bots were used. Maybe they were, but I mean, Kendrick did his thing, so that's all I have to say. Number 14. To date, Not Like Us has almost 900 million streams on Spotify and holds a record for the biggest single-day streams of a hip-hop song and most streamed diss track in Spotify history. Not Like Us has spent 27 weeks on Spotify's cities chart for the New York City, which ranks the weekly streaming popularity of songs by users in New York. Within a few weeks of its initial release, Not Like Us broke the record for the most streamed song in a 7-day period with 96 million streams. After UMG published the video, Not Like Us returned to the #1 spot on Billboard Hot 100, and in the same week, the song was streamed an additional 53.8 million times and played on the radio an additional 40 million times. From July 4th to August 8th of 2024, the video ranked first on YouTube's weekly top music video charts. On November 13, 2024, the iHeartRadio leaderboard reported that Not Like Us was the second most popular song on the platform. On New York radio, Not Like Us remains, as of date of this filing, a top 40 hit on the popular music and hip-hop stations, including Z100, Power 105.1, and WQHT. From May 9th of 2024 to August 15th of 2024, the song was among the top 10 of all songs streamed in New York City. Hey, Tony, did I see you pop in here? Please. This isn't a good look for Drake. I agree. It's like calling the police, right? At like a high school party. You're not supposed to call the police. Am I getting things mixed up? But I felt like it was very much shady, if you ask me. Not Like Us, exactly. Good to see you, Penny. I appreciate you for being here, Cole. And who else? Yes. Shout out again to Shadow Dragon for gifting today. Let's move on. Number 16, UMG touted the record-breaking business success. On July 16, 2024, Interscope reposted on X that the song had become, quote unquote, the best-selling rap song of 2024 in the US. On July 24th, 2024, UMG posted on its X account about the song charting as the most streamed song of the week. On August 29th, 2024, UMG posted on X with a link to a Summer Hits 2024 playlist by Spotify and the caption, Song of the Summer. UMG fam lands 4 out of 5 on at Spotify. Birds of a Feather, Billie Eilish, Hot to Go, Chaplin Roan, and Not Like Us, Kendrick Lamar, and Espresso by Sabrina Ann Lynn. I think that's Sabrina Carpenter, right? UMG schemes to artificially inflate the popularity of Not Like Us were motivated, at least in part, by the desire of executives at Interscope to maximize their own profits. UMG executives have an annual incentive program pursuant to which they are rewarded. Pause. UMG executives have an annual incentive program pursuant to which they are awarded for meeting and surpassing sales and profits projections, among other metrics. The incentives are largely based on specific UMG division rather than the performance of UMG more generally. For example, the annual incentive or bonus of Interscope CEO John Janik is based 90% on the financial success of Interscope and only 10% of the financial success of UMG generally. Thus, on information and belief, Mr. Janik and other executives at Interscope have been incentivized to maximize the financial success of Interscope through promotion of Not Like Us and its revitalizing impact on the artist's prior recording catalog, including his first 5 studio albums, which are owned by Interscope. Petitioner has received information that UMG has been taking steps in an apparent effort to conceal its schemes, including but not limited to by terminating employees associated with or perceived as having loyalty to Drake. Indeed, UMG has demonstrated that it has no interest in taking responsibility for its misconduct. Over the past several months, Drake has reportedly sought to engage UMG in discussions to resolve the ongoing harm he has suffered as a result of UMG's actions. Harm? We might be a little petty today. Like, what? Okay, so Drake wants to file a lawsuit or whatever when things don't go his way and he doesn't want to take the L, right? If you were to ask me, my opinion, Melly's opinion, Not Like Us, and Meet the Grams were, I mean, that was it for me. But I feel like why go this route? And like I said at the beginning, is Drake obviously feels comfortable to file these kinds of legal documents against big wigs, right? So it makes me think that there's something else going on. I don't know. What do you guys think? I'm curious. Now I lost my place. Oh yeah. He suffered ongoing harm as he suffered results of UMG's actions. UMG refused to engage in negotiations and insisted that UMG is not responsible for its own actions. Instead, UMG has pointed the finger at Mr. Duckworth, which is Kendrick Lamar, and insisted that Drake should initiate legal action against Mr. Duckworth rather than UMG, and even threatened to bring its own legal claims against Mr. Duckworth if Drake were to pursue legal claims against UMG. Streaming and licensing is a zero-sum game. Every time a song breaks through, it means another artist does not. UMG's choice to saturate the music market with Not Like Us comes at the expense of other artists, like Drake. Drake is a petitioner's sole owner, and petitioner owns the copyright to Drake's entire catalog. Petitioner suffered economic harm as a result of the UMG scheme. Moving on, the parties involved. Petitioner Frozen Moments LLC is a limited liability company registered in the state of Florida. Frozen Moments is an entity wholly owned by Drake, through which Drake furnishes its recording services as a vocalist and musician and its copyright holder of Drake's sound recording, including music videos. As such, petitioner competes with Interscope. Respondent UMG, so was I wrong earlier? No, I was right. Kendrick is under Interscope, Drake is under Republic, but they're all under the umbrella of UMG. Respondent UMG is a wholly owned subsidiary of Universal Group, a publicly owned limited liability company incorporated under the laws of the Netherlands. UMG is a Delaware corporation registered to do business in the state of New York. UMG has divisions including but not limited to Interscope, which represents Mr. Kendrick Lamar Duckworth, and Republic Records, which represents Drake. Interscope's publicity team operates out of 1755 Broadway office. So I was right in saying that they're against each other, but they all fall under the same umbrella. Respondent Spotify USA, Delaware corporations with headquarters in New York City at 4 World Trade Center in New York. Spotify is a digital music podcast and video service. The court has personal jurisdiction over UMG pursuant to CPLR 302. UMG regularly transacts business within the state, including by doing business and entering into contracts with New York-based Spotify, licensing and promoting music to streaming and radio broadcasting services within the state, and supplying its musical management and publicity service in the state. The events at issue, including UMG's licensing contract with Spotify and payments to New York-based radio stations to inflate the popularity of the song, and it occurred within the state. UMG also owns and uses or possesses real property at its 1755 Broadway office, where it hosts offices for its catalog division and publishing arm, Universal Music Publishing Group. UMG employs numerous individuals within the state as its marketing partnerships, media and properties, and publicity professionals operate out of the New York offices. This court has personal jurisdiction over Spotify pursuant to CPLR 302. Spotify regularly transacts business within the state, including by doing business and entering into contracts with paying and non-paying subscribers based in New York and promoting its streaming services within the state. The events at issue, including Spotify licensing contract with UMG, occurred within the state. Spotify uses its 4 World Trade Center as its corporate headquarters. Frozen Moments has commenced the special proceeding pursuant to CPLR 3102 to seek pre-action discovery to allow the petitioner to 1. Identify appropriate defendants and frame a complaint for a claim under the RICO Act. 2. Identify appropriate defendants and frame a complaint from a claim under Section 349 of the New York General Business Law. 28. Civil RICO. Petitioner has a viable cause of action for a civil RICO, which predicate acts of wire fraud, mail fraud, and a bribery for UMG's payments to unknown third parties in the form of reduced licensing fees to Spotify. However, petitioner requires additional information in order to frame his complaint and satisfy the heightened Rule 9b pleading standard applicable to complaints sounding in fraud. Specifically, petitioner requires information about the method by which third parties were paid in order to determine which underlying predicate acts to plead, and requires information about which benefits were conferred upon UMG in exchange for the payments. Additionally, petitioner lacks sufficient information to identify third parties who acted in conspiracy with UMG. Life artist, you made it. Good to see you, love. And Scott, I saw you in here as well. Now I'm just hearing DuckTales. Woohoo, man. No more certified lover boy, I think. I think after this live, I'm going to go watch Not Like Us again. We're going to watch it together since he didn't copyright. That's one thing I do like about Kendrick Lamar with Not Like Us. I can stream it on here without getting no copyright. And if you know about copyright, it's a pain in my ass on YouTube. Even like my small channel, you know, sometimes it comes up, but we might listen to that in a minute. Deceptive business practices and false advertising. Petitioner has information that agents of UMG paid at least 1/3 party to use bots to stream the song on Spotify. And on information and belief, this practice extended to multiple third parties to artificially stream the song and video. UMG also gave financial benefits to Spotify and other unknown third parties to promote and play the song and video without disclosing payments. UMG then touted the success of the song and video, knowing the success was artificially inflated by its own manipulation. These practices harm consumers. That's you and I, baby. You and I, we're consumers. They also violate the New York Deceptive Business Act and New York False Advertising Act. Without the requested pre-litigation discovery, petitioner lacks sufficient information to identify the known but anonymous third-party streamer and to identify any additional streamers who UMG paid. Petitioner also lacks sufficient facts to frame the complaint regarding what was exchanged for UMG's payments. Petitioner seeks the following limited pre-action disclosure from UMG. 1. Documents and communications sufficient to show the identities of all third parties that UMG, its agents, or anyone working on behalf of UMG Interscope paid to promote, publish, or recommend the song, its accompanying cover or video, including but not limited to radio stations, influencers, music platforms, and music publications, as well as the dates, methods, and amounts of those payments. Number 2, documents and communications sufficient to show the identities of all third parties that UMG and its agents or anyone working on behalf of UMG paid to use bots or any similar technology to stream the song or video, as well as the dates, methods, and amounts of those payments. Number 3, documents and communications sufficient to show what third parties agreed to provide and did to provide in exchange for these payments. Petitioner seeks the following limited pre-action disclosure from Spotify. Number 1, documents and communications sufficient to show the dates, methods, and amounts of financial benefit, whether in the form or direct payment of reduced licensing fees provided by Spotify, UMG, Interscope, its agents, or anyone working on behalf in exchange for the promotion, publication, or recommendation of the song on Spotify. And 2, documents and communications sufficient to show what Spotify agreed to provide and did provide in exchange for any such benefits. 32, petitioner has further commenced the special proceeding pursuant to CPLR 30102 to seek an order acquiring UMG, including Interscope and all other divisions, as well as UMG directors, officers, relevant employees, to preserve all documents and communications regarding the song, image, and video during the pendency of any litigation that petitioner commences against respondent and or any unknown third parties for the underlying cause of action discussed herein. Petitioner expects that much of the relevant evidence will be in the form of messages on social media platforms, payments, and text messages, including but not limited to iMessage and WhatsApp, which may not be preserved in the usual course. Petitioner is aware that senior executives at UMG regularly communicate for business through messaging platforms and applications. Oof. Exhibit A, to the verified petition is proposed subpoena, 𝐷𝐶𝐿𝐴 to UMG, commanding UMG to produce the UMG requested information. Exhibit B, Exhibit C, subpoenas. Wherefore, petitioner respectfully requests that the court enter an order pursuant to CPLR 3102, respondent UMG to provide to petitioner within 14 days of service on UMG by overnight mail a copy of an order with notice of entry, documents, and communications, and then provide overnight mail order copy, again, Exhibit B and Exhibit C. Basically, that's it. We got to the end of that. So that was the first petition that Drake filed against UMG and Kendrick. And now we're going to see a second one. My name is Drake and I want more money for a song I didn't write. Boohoo. Yeah, exactly. It seems like when it didn't benefit him, he was like, I'm done, I'm out, right? I don't know. That's just my opinion though. Let's move on. Wow. Let me pull up. Bear with me here, please. I'm going to play Not Like Us for 1 second while I get my water. Since I do not get copyrighted on this, I'm like, why not play it, right? I appreciate you guys for being here. So I'm going to share it while I go get my water so that I can drink and stay hydrated.
I am reincarnated. I was stargazing.
Oh, wait, I'm sorry. That's the wrong video. I'm sorry. I was playing earlier a bunch of videos regarding this song. Here we go. I'll play this one. Let me know if you can hear it. Let me go back. Y'all are like, no, Melly, we don't want to listen to that. But I had to go fill up my water bottle. So let's move on. Second part. This is the new recent filing. He filed 1 and then he filed 2. So now we're going to play the second one. I'm sorry, not play, read the second one. Let me know if you guys can see it. Yeah, you guys can see it? Okay, good. So this one was on 11/25, and this one is regarding Aubrey Drake Graham. So as you saw, the previous one stated Frozen Moments LLC, and now this is Aubrey Drake Graham. I know, Sarah. Thank you, Augie. Yeah, I get my water bottle. Okay, let's move on. I'm going to read the second document. This one we'll probably get through pretty quick since we just read the first one and it's pretty similar. Give me one sec. Okay, so this is the second one filed. Here we go. Oh, crap. Sorry. Tech issues here. I'm not perfect. That's funny, Augie. I have to see that. Okay, let's move on. Aubrey Drake Graham verified petition. Petitioner Aubrey Drake Graham requests an order authorized. Okay, we'll move past that. Factual background. Respondent UMG is one of a handful of companies that dominate the multi-billion-dollar music industry. When it comes to the release of new music by its most prominent artist, UMG is meticulous in planning and execution of the music it releases, promotes, and backs with its considerable financial resources. That is not true just because of the amount of money on the line for UMG and its shareholders, but also because UMG's executives are eligible to receive incentive bonuses based on the revenue generated by their respective divisions. Account with Drake. Earlier this year, one of the artists that UMG has under contract presented UMG with a new song called Not Like Us. Before it approved the release of the song, UMG knew that the song itself, as well as its accompanying album art and music video, attacked the character of another one of UMG's most prominent artists, Drake, by falsely accusing him of being a PDF file, engaging in PDF acts, harboring offenders, and committing other criminal acts. Specifically, the song's called Drake a certified a predator and someone whose name should be registered and placed on neighborhood watch. Pursuant to its rights under various contracts, UGM has exclusive control over the licensing of Not Like Us and could have refused to release or redistribute the song or require the offending material to be edited and or removed. But UMG chose to do the opposite. UMG designed, financed, and then executed a plan to turn Not Like Us into a viral mega hit with the intent of using the spectacle of harm to Drake and his businesses to drive consumer hysteria and, of course, massive revenues. That plan succeeded, likely beyond UMG's wild expectations. Life Artist says, is this a Kendrick bag Drake good situation? I'm real late. I think Drake like lost the feud. Like, I'm not really into it, but like the deep facts of it. But according to what I have listened to and know, Drake probably didn't take the L very well. Interesting, and that's one of the things I think he brought up too, is the Millie Bobby Brown situation. Whatever. I mean, if it's a rap battle, and then didn't Drake like bring up Kendrick's family? So I don't know. What do you guys think? UMG released the song Not Like Us on May 4th, 2024, and its music video on July 4th, 2024. UMG relied on its exclusive licensing rights and, in coordination with known and unknown third parties, utilized every tool in its arsenal to spread Not Like Us. UMG made Not Like Us available for radio play, including to iHeartMedia, a mass corporation headquartered in San Antonio, Texas. iHeartMedia boasts that it is #1 audio company in the U.S. based on consumer reach. iHeartMedia claims that it reaches 9 out of 10 Americans every month and has more reach than any other media company in the U.S. iHeartMedia owns iHeartRadio, a freemium broadcast, podcast, radio streaming, and music streaming platform. Radio stations all over the country, including stations owned by iHeartMedia, have played Not Like Us. UMG and iHeartMedia have a long-standing symbiotic business relationship where iHeartMedia pays UMG to license and collect royalties for UMG artist songs over the radio airplay and streaming services. Again, we see the word symbiotic, and that means that they work in tandem to benefit each other's goals, business and professional goals. As demonstrated by iHeartMedia's bankruptcy filings in 2018, the amount of money exchanged between iHeartMedia and UMG is substantial. In the last quarter of 2023, UMG, through its recorded music and music publishing divisions, had an ownership interest in more than 60% of the 100 songs listed on Billboard Hot 100 radio charts. Without its business deals with UMG, iHeartMedia would lose access to majority of its top radio hits. Sarah says, either way, he's a grown man. She was most definitely a kid. Oh, yeah, you're talking about the Bobby Brown thing. Right, Life Artist. And that week, that Not Like Us music video was released. Not Like Us played on the radio an additional 40 million times. 4 months later, the iHeartRadio leaderboard reported that Not Like Us was among the top two songs with the most plays on iHeartRadio station, and explained in a newsletter that it had been heard more than 25 million times across iHeartRadio's platforms alone. As of the date of this filing, 11/25, the iHeartRadio leaderboard still reports Not Like Us as among the most widely played songs on iHeartRadio stations. Billboard reported that as of October 7th of 2024, Not Like Us reached 45.4 million in total audience impressions on radio, with 15 non-consecutive weeks in charge of the R&B and hip-hop airplay list. Radio was only one of the mediums on which UMG relied to spread Not Like Us. Within a week of its initial release, Not Like Us broke the record for the most streamed song in a 7-day period with 96 million streams. On October 7th, 2024, Not Like Us broke the record for the most weeks, 21, at #1 on Billboard's Hot Rap Songs based on streaming sales and radio airplay. Since its initial release, Not Like Us has been seen and heard billions of times. The record-shattering spread of Not Like Us on streaming sales and radio play was deliberate and appears to have relied upon irregular and inappropriate business practices. According to one inside source known to Petitioner, UMG made covert payments to a number of platforms, including radio stations, to play and promote Not Like Us without disclosing those payments to listeners. This practice is known as payola, is prohibited by the Communications Act of 1934, and has been the subject of regulatory scrutiny. In 2006, UMG agreed to pay $12 million in a settlement with New York Attorney General following an investigation involving claims and accusations that UMG executives had used a broad array of pay-for-play tactics to secure radio airplays for music. Separately, in 2005, UMG was sued by 2 radio promotion companies alleging fraudulent pay-to-play practices. Petitioner has learned of at least one UMG employee making payments to an independent radio promoter who had agreed to transfer those payments to certain radio stations and/or radio station employees. These radio stations subsequently played Not Like Us, and to petitioner's knowledge, did so without disclosing to their listeners that they had been paid by UMG to do so. Petitioner has been unable to confirm whether any iHeart radio stations were among the stations paid as part of UMG's pay-to-play scheme, or whether there were any direct payments to UMG to iHeart radios to promote Not Like Us. Given iHeartMedia's status as the #1 audio company in the country, petitioner believes that UMG engaged in similar tactics to drive radio play of Not Like Us on iHeartMedia stations. UMG also directed its digital marketing team to use discretionary funds provided or reimbursed by UMG to pay unknown third parties to share the Not Like Us song and video in the days after they were released. The purpose of UMG's payments to third parties was to inflate artificially the metrics reported relating to Not Like Us, to encourage media and music critic commentary, and ultimately to make it go viral. One whistleblower, whose identity is unknown, revealed publicly that someone from management paid him thousands of dollars on May 6, 2024 to use bots to achieve 30 million streams of Not Like Us on Spotify, and in the days immediately after its release to turn Not Like Us into a crazy hit. Bots appear to be real social media accounts, but are in fact software programs designed to mimic human behavior. Petitioner has received information that UMG also paid certain third-party influencers to promote Not Like Us. In order to create incentives for high-visibility influencers to spread Not Like Us, and what appears to be a radical departure from long-standing internal policy at UMG, UMG removed copyright restrictions on Not Like Us on YouTube and Twitch, thereby whitelisting the song. Petitioner brings this action for a discrete and specific purpose to understand whether and how UMG funneled payments to iHeartRadio and its radio stations as part of a pay-to-play scheme. Petitioner has amassed sufficient facts to pursue certain tortious claims against UMG, including but not limited to a claim for defamation, but currently lacks factual support necessary to determine whether he may bring claims of civil fraud and racketeering against UMG and its many unidentified co-conspirators who violated payroll laws and accepted illicit payments and other things of value from UMG without disclosure. Augie, I love you. Yeah, hit the like, make sure. I know some people are just not into like this kind of stuff, but I feel like these are good legal documents I needed to cover. He's just creepy having a tantrum that money hasn't. Right, Penny, I agree. It's all about money here and clout. So we know the parties and deponents. Drake is an individual residing in Washington County, Texas. iHeartMedia is an audio media company incorporated in Delaware. UMG is a wholly owned subsidiary of Universal Group, a publicly owned limited liability company incorporated under the laws of Netherlands. We're going to skip the jurisdiction part and just move on to request to depose. Rule 202 permits a party to investigate potential claims via pre-suit depositions in aid of a suit which is anticipated and ancillary to the anticipated suit. Depositions under Rule 202 are governed by the rules applicable to depositions of non-parties in pending suit, and the scope of discovery and depositions authorized by this rule is the same as if the anticipated suit or potential claim had been filed. Here, the limited Rule 202 depositions petitioner proposes are the most efficient method for him to understand the role of iHeartMedia and UMG's scheme to unlawfully promote Not Like Us. Based on the minimal information already available to petitioner, the testimony sought is necessary for petitioner to understand and evaluate his potential claims. Because petitioner only seeks this limited testimony, the benefit of allowing petitioner to take the requested deposition outweighs any associated burden or expense to iHeartMedia and UMG. Moreover, the interest of justice is served by allowing petitioner to investigate potential claims before filing. These depositions are necessary as part of the requirement of the Texas rule for petitioner to make an informed decision about any further legal action. Petitioner seeks an oral deposition of iHeartMedia via corporate representatives to investigate the evidence of UMG's provision of financial benefits to iHeartMedia in exchange for obtaining airplay of Not Like Us, to spread the song to billions of listeners, and to learn the identities and practices of any direct participants in a pay-to-play scheme, including any intermediaries who have been involved. Petitioner seeks an oral deposition of UMG via corporate representatives to investigate evidence of UMG's conspiracy to increase radio play for Not Like Us by providing iHeartMedia with financial benefits, and to learn the identities and practices of any direct participants in a pay-to-play scheme. Critical evidence relevant to petitioner's potential claims, including the identities of potential defendants, is not available to him. The benefit of allowing the requested deposition outweighs the burden or expense of the procedure. Texas P202 enables a person to petition the court for an order authorizing the taking of deposition to investigate a potential claim or suit. A court must order a deposition requested if it finds that the likely benefit of allowing the petitioner to take the requested deposition to investigate a potential claim outweighs the burden or expense of the procedure. Critical evidence relevant to petitioner's potential claims, including but not limited to the identities of unknown defendants, is not available to him, and without the requested deposition, he may be unable to pursue such claims. For the reasons set forth above, petitioner avers that the likely benefit of allowing petitioner to take the requested deposition to investigate potential claims outweighs the burden of the expense of the procedure. It says other interested persons. Petitioner is unaware of other interested persons at the time. Relief. Petitioner respectfully requests that the court issue an order setting a date for the hearing on this petition within at least 15 days of notice, and after that hearing, issue an order requiring iHeartMedia's corporate representative to testify by oral deposition related to the matters, or requiring UMG's corporate representative to testify by oral deposition as well. So that's the second one that we see that Drake has filed. And now, okay, so we read the two Drake action suits, lawsuits, whatever. And now we're going to move on to Diddy. So if you missed the first part of this live, Diddy did not get bail for the third time. He was denied, and it was denied because the government could not ensure the safety of the community. So we should read the docket from Diddy. We're going to start with document 85. If you didn't follow the previous one, the previous live, I covered a bunch of those documents. So let me pull that up. These are pretty quick. They're pretty short. So we will get through these pretty quick. So document 85, now we're moving on to Diddy. This is document 85 filed on November 25th, and this is to the judge. So Diddy did not get bail for the third time, which I'm kind of glad about that, but that's wild. I don't know if I believe about the bot. I agree, Sarah. That's the whole thing, is like, I think the rap song was actually good. I'm sorry, I enjoy you, Melly, but the more you read, the sillier the lawsuit is. Yeah, we're done with the Drake. That was it. Like, I've had enough Drake. He is definitely not the certified lover boy. Now we're moving on to Diddy. Yeah, so he didn't get bond. No, he didn't. I just saw that before I came live. But let's see what this document says. Let me make it bigger for you guys to be able to see. Okay, give me one sec, and we will start reading this. Okay, let's see. So this was filed, like I said, on November the 25th. So we're reading November 25th, 26th, and 27th. And 27th is today. And it was just released before I came live. So, dear Judge Sabrine, Defendant Sean Combs respectfully submits this letter in response to the court's request at the November 22nd hearing for further briefing on the contours of the types of communications that Mr. Combs is able to engage in and consistent with the court's order and rule. For months and months, government's agents, plaintiffs, attorneys, and others with questionable motives have been polluting the airwaves with false and outrageous claims about Mr. Combs. The nonstop drumbeat of negative publicity has destroyed his reputation and will make it virtually impossible for him to receive a fair trial. Mr. 𝐂𝐚𝐬𝑡𝐴 is not required to say idly by acquiesce to all of this. He has a right to a fair trial and a constitutional right to speak out on his own behalf. The government's arguing that asking his children to post birthday wishes on Instagram and that he is not entitled to publicly express his opinion that the prosecution is racially motivated are quite simply an unconstitutional effort to silence him. We didn't make anything up. Like, we saw that video with Cassie. Yeah, exactly, Sarah. It was amazing. Okay, let's move on. So, Mr. 𝐂𝐚𝐬𝑡𝐴 sought only to stop a wave of publicity he perceived as prejudicing potential jurors and injuring his reputation in the community. His communications directed at the public are protected speech under the First Amendment and cannot justify denying bail or indeed preventing him from engaging in constitutionally protected public relations efforts, so as long as they comport with carefully tailored legal limits imposed by the controlling authorities described below. 1. Mr. 𝐂𝐚𝐬𝑡𝐴's communications regarding potential public statements and social media posts constitute speech protected by the First Amendment. The most demanding scrutiny applies when deciding the issue. In United States versus Trump, assume without deciding that the most demanding scrutiny applies to pre-trial speech restrictions on criminal defendants and that only a significant and imminent threat to the administration of criminal justice will support restricting a defendant's speech. So now he's bringing the whole situation with Trump on here. He's involving that case. The court considered but rejected application of the less exacting substantial likelihood of material standard articulated in 𝐁𝐿 versus State Bar of Nevada, which considered a professional disciplinary sanction on a criminal defense lawyer pursuant to ethical rule. 𝐁𝐿 standard relies, if I'm saying that right, relied in part on lawyers' special duties and roles as officers of the court. And the Supreme Court has never decided what standards of review applies to a criminal defendant's own speech. Because Mr. 𝐂𝐚𝐬𝑡𝐴 is a criminal defendant and is presumed to be innocent, he has a greater constitutional claim other than the trial participants, including counsel, to criticize and speak out against the prosecution and criminal trial process seek to take away his liberty. Accordingly, the court should apply Trump's heightened standard when considering Mr. 𝐂𝐚𝐬𝑡𝐴's speech here, for the same reasons which Local Criminal Rule 23.1, which employs a substantial likelihood formulation, is only enforceable to the extent it withstands Trump's higher level of scrutiny with respect to speech at issue. Although, to be clear, as explained at the November 22nd hearing, the infra, the communication at issue, would not violate the court's order or the local rule anyway. The Second Circuit has held per se proscriptions of certain types of speech in the trial context are quote-unquote overbroad and violate the First Amendment. Thus, when enforcing such rules, such as the Criminal Rule 23.1, the court must examine the specific speech in light of record evidence to determine if it risks undermining a fair trial. Local rule generally categories of presently prejudicial speech are non-dispositive of the question, regardless as explained at the November 22nd hearing, and further infra, the communications at issue do not violate the rule. In making these determinations, the court should consider such factors as the speech, phrasing, timing, setting, and meaning. The court should also consider the forms of media at issue and their circulation, as the mere presence of extrajudicial comments in some forms of media does not by itself establish the potential for prejudice of jury veneer without a more thorough examination of that potential. C. The speech at issue does not risk undermining a fair trial. The government cited examples of Mr. 𝐂𝐚𝐬𝑡𝐴's speech do not even come close to the side of the line that's improper illegal conduct. Rather, the examples concern core protected speech. The government argues that Mr. 𝐂𝐚𝐬𝑡𝐴's children's social media posts showing them gathered to celebrate his birthday, evidence obstruction and violate this court's gag order. The government further argues that statements that Mr. Combs is a revolutionary and that the prosecution is a racist could be obstructive. While the government conceded that a PR campaign or marketing strategy is unobjectable, it claims that speech is punishable here because Mr. Combs made comments such as wanting to reach for this jury. I just need one. TR 15. In other words, the government argues it is a defendant's stated intent that he wants to influence the jury, and that is problematic. Diddy just won't stop. Mr. Combs did not make public statements and attempt to discredit testimony for the prosecution or make evidence available to news media. The speech does not concern any attempt to publish court-ordered discovery. Moreover, the speech at issue does not come near any of the local criminal rule 23.1 categories of presumptively prejudicial speech. It does not concern information likely to be inadmissible at trial. Mr. Combs' speech falls on the opposite side of the line. It is clearly protected. Anticipated speech about being a revolutionary or about being a racist. Prosecution involves thoughts that the prosecution is politically motivated or that he is innocent of the charges against him. Core protected speech. Mr. Combs' anticipated words were directed at public officials and their conduct in office. There is no question that speech critical of the exercise of the state's power lies at the very center of the First Amendment. The plurality of opinions and 𝐁𝐼 is further instructive on this point. The plurality concluded the statements that the state sought the indictment and conviction of any innocent man as a scapegoat, likening the police department to crooked cops, did not demonstrate any real or specific threat to the legal process. Rather, the plurality concluded such statements have the full protection of the First Amendment. As for Mr. Combs' children's birthday wishes, that message was entirely innocuous. It cannot possibly produce an interference that is material, nor was a message made with the knowledge that such interference is highly likely to result or made intending to delay or obstruct the justice process. It is no response to cite that Mr. Combs' subjective hope that his birthday message which reach the public, including potential jurors. Mr. Combs' reputation is drowning in a sea of negative publicity prompted by the government's prosecution here, as well as dozens of civil lawsuits, and he is free to defend himself in the court of public opinion, which all the statements cited by the government's evidence. Indeed, as noted in Mr. Combs' reply, a core assumption underlying 𝐁𝐼 in the First Amendment is that press comment is sometimes necessary to protect the rights of the defendant and to defend his reputation, because a defense does not begin inside the courtroom door, and one cannot ignore the practical implications of legal proceeding for the accused. The government is essentially arguing for standard in which the entire press community and civil plaintiffs and the government itself can wage war against Mr. Combs' reputation, but Mr. Combs can't even try to influence public opinion himself in the response. That is simply not the law. Even if the speech at issue comes close to the line, which again it doesn't, before deeming it impermissible and punishing Mr. Combs, the court must consider less restrictive alternatives. Alternatives such as searching voir dire and emphatic jury instructions are more than adequate here, and trial courts should resort to these alternatives whenever possible prior to gagging speech. At the hearing, the government was unable to answer the court's question concerning the meaning of obstruction and had no response to the fact that it cited obstruction precedents and are clearly distinguishable here. Indeed, when asked, the prosecutor said, quote unquote, obstruction, I think it's broad. I don't think it has to be just what fits into the narrow categories of statutes in Title 18, but failed to cite any authority for its argument and failed to articulate any clear or ascertainable standard. The government's position invites the court to adopt a test so vague that it fails to give ordinary people fair notice of the conduct it punishes, and so standardless that it invites arbitrary enforcement. And in addition to being unconstitutionally vague, the government's proposal would chill otherwise constitutional protected speech. As outlined in Mr. Combs' reply brief, the other communications cited by the government reflect Mr. Combs' effort to investigate and prepare his defense, including with counsel's participation, nothing more. His intent in requesting contact with potential witnesses, for example, is clear from the record. Quote unquote, I'm telling you, to hook up with my lawyer because that's not part of a job. I'm not obstructing, no laws, nothing. The statement cited by the government evidenced neither an obstructive intent nor actual obstruction. To be clear, if released, Mr. Combs will accept any condition that instructs him to avoid all contact with an alleged victim and with a potential witness as permitted by the Bail Reform Act. In other words, despite having a constitutional right at the end of the day to assist his lawyers in getting witnesses, Mr. Combs will avoid contact directly and indirectly other than through counsel with any persons who may be a victim or witness. While detained, however, and in the absence of such condition, the status quo remains that Mr. Combs has a constitutional right to assist his lawyers in reaching out to witnesses. By foregoing reasons and those set forth in Mr. Combs' prior submissions and oral argument, this court should grant bail on the proposed conditions or any other conditions that the court seems appropriate. So that was document 85. And as we know from when I previously told you, he has been denied bail. So we're going to move on to the next document. I might skip this one because it's quite long. So let me touch base with you guys. But if, thank you, Augie. I appreciate you. I know. I'm still around though for chats and other channels. He sold some of the videos as will eventually leak. Yeah, I agree, Aaron Carter. Okay, so the next document is document 86. Let me pull it up. Okay, here we go. I'm going to skip some of these because it's what we just heard about him asking for bail. Let's see. It says the government respectfully submits this letter in further opposition of defendant's renewed application for bail and following November 22nd, 2024 bail hearing. Moreover, as detailed in prior hearings and briefly addressed below, the defendant's history of obstructive conduct is part and parcel to his decades-long of violence, which must be considered along with his obstructive conduct to fully assess his dangerousness under the Bail Reform Act. A holistic view of this obstructive and violent conduct that is still happening presently, makes clear that there's no way to rebut the applicable presumption of detention in this case. The bail package presented by the defendant does not come close to ensuring the safety of the community, including from the defendant's ongoing efforts to obstruct this case, nor does it adequately protect the risk of flight. For all of the other reasons, defendant's renewed application for bail must be denied. I'm not going to read through all of this one. It kind of states the same things we read previously about the photos and the legal file that, they searched the MDC and how he orchestrated the whole birthday campaign. So I'm going to start. Yeah, we're not going to read through all of this. We already read through all of this. The BOP, the legal documents, the pictures. Okay, we're going to move on to the next document. I'm not going to read over stuff we already know about. So that was document 86. And now we're going to go to document 87. And this is also to the judge. Oh, let me share. States, we respectfully submit this letter on behalf of defendant Sean Combs in response to the government's letter submitted. The government's 13-page letter rehashes old arguments, adds new arguments, and seeks to supplement the factual record, even though the parties have already provided full briefing and the court held a long, lengthy bail hearing on Friday, November 22nd, 2024. The court asked the parties for shorter letters on a very specific legal issue. Mr. Combs' letter responded to the court request and addressed only that issue. Mr. Combs objects to the government's submission to the extent it goes beyond responding to the court's specific question and requests that the court not consider any new or repetitive information in the government's letter. Okay, so that was document 87. And now we're going to go to document 88, document 89. Document 88 is not available yet. It's sealed. So now we'll go to document 89. And it says notice of filing of official transcript. Oh, they're trying to, we don't need to read document 89. They're just trying to get the transcript redacted for some reason. Document 90. And this one's filed on November 26th, yesterday. It says, Dear Judge, the short letter is in response to the government's letter of yesterday and updates on the court issues discussed at Friday's conference. Following Friday's conference, the defense located and then redacted. This whole paragraph is redacted. This is an important safety measure that ensures the safety of Mr. Combs, the security detail, and others. We have attached several photographs taken on November 25th, 2024 of the building. And then it shows photographs redacted. A security professional is coming to the location on the morning of November 26, 2024 to assess the location, including the placing of cameras and other security measures. We have also spoken with pretrial services, which indicated that in the event Mr. Combs is granted release on conditions, it would want to inspect the location prior to Mr. Combs residing there. In regards to the concerns raised by the government, the stringent measures laid out in our bail proposal include, as the court will recall, that Mr. Combs will not have access to a cell phone. Rather, the cell phone will be in exclusive possession of the security detail, which will keep a written log of all incoming, outgoing calls, text messages, etc. Accordingly, all such communications will be maintained both in the written log and within the phone itself. Without getting the merits of the government's various allegations, because these conditions adjust them all, while also ensuring that Mr. Combs has full access to his counsel to prepare for trial and defend the over 30 lawsuits in which he is a defendant. We thank the court for the time and attention it has devoted to our application. So if he's released on bail, which was denied, he claims that he wouldn't have a cell phone. Who buys that? With all that money, I don't buy that. I just don't buy it. I definitely agree he shouldn't ever get bail. Well, he didn't get it. So I'm glad no bail for 𝗟𝐿𝐴. Never. Exactly. Never. Okay, so let's move on to document 91, and then we'll get to the one that was filed today, which denied his bail. So this one states, to Judge Submaranian yesterday as well. The government submits this letter in further response to the court's inquiry on the November 22nd bail hearing to the defendant's proposed conditions of release. After reviewing the transcript, the government recognizes that it may have misunderstood the court's initial questions. To clarify, as set forth in the government's opposition briefing and at the hearing, the government is seeking the defendant's detention based on his danger to the community, including the serious risk of obstruction of justice he poses, as well as the defendant's risk of flight. Because the government does not seek detention based on risk of flight relying primarily on the defendant's personal wealth, Bastoni's holding applies here. The defendant is not permitted to avoid detention by relying on his own financial resources to pay for private jail. Private jail? Geez. Does everybody have that luxury? No. As the Second Circuit and Bastoni clarified, Sabani applies only in limited circumstances where the defendant is deemed to be a flight risk, primarily because of his wealth. The conditions proposed by the defendant are therefore barred under Bastoni as they amount to a two-tiered system, which is precluded under the Bail Reform Act. The government sincerely apologizes for any advertent miscommunications to the court in response to your Honor's questions at the hearing regarding this issue. And that was respectfully submitted by Damian Williams, the United States Attorney. It even bothers me when they call him Mr. Combs. That's not his name. I agree, Augie. It bothers me too. That's funny how little things like that bother us. Okay, so now we're going to get to the document filed today. Yes, today he got denied bail just right before I went live. So let me pull it up. And this is the last document we will be reviewing for the diddler. So filed 11/27. It says defendant Sean Combs renewed his motion for bail on November 8th. The court held a hearing on November 22nd, and the parties filed supplemental letters on November 25th and 26th. For the following reasons, Combs' motion is denied. Denied. Right there. Denied means no. You see that? Denied today. Let's move on. It says, no condition or combination of conditions will reasonably assure the safety of the community. So it says the court has evaluated each of the factors that it must consider. The weight of the evidence against the person, history and characteristics of the person, the nature and seriousness of danger that would be posed by the person's release. The court has also reviewed the information submitted by Combs and the government across all three bail hearings. The court finds that the government has shown by clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of the community. In support of the finding, the court provides the following reasons. A rebutable presumption of detention applies to this case. Even if Combs successfully rebuts this presumption, it remains one of the factors that the court considers in determining whether the government has met its burden of persuasion. Number 2, the indictment charges Combs with serious and violent crimes. It alleges that for decades, Combs abused, threatened, and coerced women and others around him to fulfill his sexual desires, protect his reputation, and conceal his conduct. To do so, Combs relied on the employees' resources and influence of the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in and attempted to engage in, among other sex crimes, sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. It says that Combs himself carried or brandished firearms to intimidate and threaten others, including victims and witnesses to his abuse. And notes that during searches of Combs' residences in March of 2024, law enforcement seized firearms and ammunition, including 3 AR-15s with defaced serial numbers, as well as a drum magazine. When Combs' authority or reputation was threatened, the indictment alleges he and members of his enterprise engaged in acts of violence, threats of financial and reputational harm, and verbal abuse. These acts of violence include kidnapping and arson. The indictment also charges Combs with sex trafficking in violation of Code 18. Including whether the offense is a crime of violence, whether it is a violation of Section 1591, and whether it involves a controlled substance or firearm. The government has presented direct evidence of Combs' violence. This includes video footage from 2016 and text messages between Combs and victim 1. Text messages from the hours and days following the 2016 Intercontinental Hotel incident. I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising. And then redacted. Nevertheless, Combs argues that the weight of the evidence does not support a charge of sex trafficking. In his view, it supports at best a toxic, sometimes violent long-term relationship between Combs and victim 1. But regardless of whether that's true, there's a compelling evidence of Combs' propensity for violence. There is evidence supporting a serious risk of witness tampering. For example, Combs initiated and had explained communications with witness 1, who was subpoenaed to testify before the grand jury in June of 2024, and in fact testified on July 25, 2024. Combs was represented by counsel during this time, and they have offered an explanation for some of these communications, but they cannot explain them all. For instance, Combs' efforts to call and text witness 1 even after his grand jury testimony, or Combs' deleted text with this witness. Although the phone records confirm that the defendant using a particular phone number and witness 1 exchanged multiple text messages from June of 2024 through August of 2024, there were no messages recovered from Combs' cell phone associated with that number. Further, 𝐂𝐚's interaction with witness 1 are directly in conflict with the defense's counsel representation to Judge Carter on September 18, 2024, that 𝐂𝐚's did not reach out to jury grand witnesses. He didn't do it and he wouldn't do it. There is evidence that 𝐂𝐚's violated Bureau of Prisons regulation during his pretrial detention to obscure his communication with third parties. He paid other inmates to use their PAC numbers to make calls to those not unapproved on his contact list, and instructed family members and defense counsel to add other people to three-way calls so that their communications were more difficult to trace, and used a messaging program called Contact Me ASAP. The government gives examples of 𝐂𝐚's communications utilizing means from as recently as November 4th, 2024, directed efforts to influence the jury pool or to reach out to potential witnesses. The court makes no determination that the content of 𝐂𝐚's communication through these channels was improper. However, his willingness to skirt BOP rules in a way that would make it more difficult for his communications to be monitored is strong evidence that the court cannot be reasonably assured as to the sufficiency of any conditions of release, especially given that they occurred when 𝐂𝐚's was seeking bail and when he knew the government's concerns about witness tampering and obstructions were front and center. Underscoring the court's concern despite defense counsel's assurances to the court at the November 22nd hearing that 𝐂𝐚 stopped using Contact Me ASAP as November 16th, the government indicates that 𝐂𝐚's has continued to use his service as recently as this past Sunday, November 24th. So he's still using Contact Me ASAP. His lawyers claim that he stopped using it on November 16th, but they have proof that he just used it this past Sunday. So like 3 days ago. Right, Augie, me too. Good, he shouldn't ever get out. He did so much damage to every single victim. I agree, Sarah. I agree with both of you. Let's move on. The court further notes that it held an emergency hearing on November 19th, 2024 to address the government's usage of notes on legal pads recovered from 𝐂𝐚's bunk during a sweep of the Metropolitan Center. At that hearing, defense counsel advised, quote unquote, all these legal pads say legal. Yes, they're marked legal. After the hearing, the court inquired why, in light of counsel's representation that the notes at issue were on legal pads that were clearly marked as legal, photographs taken during the sweep show no such labels. At the November 22nd, 2024 hearing, defense counsel admitted that it has to be the case that as of the day of the search, legal wasn't written on every legal pad and that they were not sure whether the pad presented to the court had legal on it at the time of the sweep. The circumstances of this incident and the misrepresentation made at the November 19th, 2024 hearing, where 𝐂𝐚's was present, bear on whether the court can be reasonably assured that any condition it imposes will be followed, or whether through inadvertence or active submersion they will be broken and the community's safety threatened. The court assumes that it may consider the bail package that 𝐂𝐚's has proposed. But see United States versus Bustani. We now expressly hold that the Bail Reform Act does not permit a two-tiered bail system in which defendants of lesser means are detained pending trial, while wealthy defendants are released to self-funded private jails. However, given the nature of the allegations in this case and the information provided by the government, the court doubts the sufficiency of any conditions that place trust in 𝐂𝐚's and individuals in his employ, like a private and security detail, to follow these conditions. So it says that they had considered it, might have considered it. Finally, the fact and circumstances here differ from those in 𝐂𝐚's principal cited authorities. In the United States versus Fox, the Second Circuit recognized the case presented an extremely close call and that any loosening of conditions or more compelling evidence presented by the government could well tip the balance in favor of pretrial detention. But in Fox, the Second Circuit did not address the risk of obstruction, and the government failed to engage with the proposed bail restrictions. In United States versus Jeffries, while the government raised danger, its possible concern with respect to defendant Michael Jeffries was flight. He had no criminal history. The alleged criminal conduct abated nearly a decade ago, and Jeffries was 80 years old. So this is in the claim that why was Jeffrey released and not Diddy? Jeffries is the Abercrombie CEO, also accused of sex trafficking. And let's move on. The court also finds that 𝐂𝐚𝐬𝑡𝐻 has not shown that a temporary release from detention pursuant to 18 is warranted. Under this provision, a judicial officer may permit the temporary release of the person in the custody of the United States Marshal or other appropriate person to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. 𝐂𝐚𝐬𝑡𝐻's application is based on conditions at the MDC, which he states make trial preparation impossible. But given 𝐂𝐚𝐬𝑡𝐻's access to counsel and documents, 𝐂𝐚𝐬𝑡𝐻 has not carried his burden of demonstrating that release from detention is necessary for trial preparation purposes under the Constitution. But the court will promptly address any issue that arises with respect to 𝐂𝐚𝐬𝑡𝐻's trial preparation, and if the circumstances materially change, he may renew his application. The motion is denied. The Clerk of Court is respectfully directed to terminate docket 60. So ordered, November 27th. Today, no bail for Diddy. No Diddy. Nope. Nope. And we're done. We're caught up on the Drake and Kendrick documents and the Diddy documents. So no bail for Diddy. Looks like he might stay locked up until his trial. And we'll see what happens with Drake and Kendrick Lamar. But we did get through the legal documents. So now we know all the facts. And I agree, 𝐂𝐚𝐬𝐡𝐻 and 𝐶𝑎RAH. He has damaged a lot of people, which I'm kind of glad he didn't get bail. But nonetheless, I appreciate you guys for being here. Make sure, let's get some housekeeping out of the way. Make sure you subscribe, like, hit the notification bell. We will be back on, I don't know, do people stream on Thanksgiving? What's up? What are you guys doing for Thanksgiving? Dragonfly, good to see you, love. Like, are you guys going to go eat food at families? Are you guys going to stay home, be homebodies? Are you guys going to be by yourself? What's the vibe? Because I was like, I don't know if I want to stream tomorrow because I feel like everybody will be with their family, but I feel like I do want to stream tomorrow because I have really good content coming up. So I'm going to be talking about 2 cases that are new to my channel in general. And for one of them, I got all the phone calls from jail. So it's not Wade Wilson. It's a total complete new case, new trial coming up. And so I've had the phone calls. I paid for them for quite some time. And I just have been slacking. I hadn't decided to go live on it. But I plan to cover those on Friday. I didn't know what the vibe was in. We don't have Thanksgiving in the UK. What? That's interesting. No Thanksgiving at all, 𝐂𝐚𝐬𝐻? Okay, so if I stream tomorrow, I know 𝐂𝐚𝐬𝐻 might be there. I'm not cooking. I'm not cooking for Thanksgiving. So we'll see. I might be back tomorrow if you don't catch me. It's a non-holiday for us. Okay, so see, that's interesting. I saw a lot of other channel creators saying they would be live. And I'm like, maybe I want to go live, but maybe I should. And we'll hear new prison calls. This is a female, by the way. I don't want to drop any names, but yeah. So if I'm not back tomorrow for Thanksgiving, I wish you all a good one. And if I do stream tomorrow, then I will see you tomorrow. If not, I'll catch you on Friday. We're going to be talking about 2 new cases here on my channel. And then once I start the jail phone calls, I might, it's a lot of them. So it'll probably keep going throughout the weekend, but they're very good. And her trial starts next week. So I do have the jail calls. Yes, I got them and I paid for them through FOIA. Okay, I'll let you know, 𝐶𝑎RAH. I appreciate you guys for being here. Make sure you hit that like button on your way out. Support your girl. And I will see you guys tomorrow. And if not Friday, and if I don't see you then, I hope you guys have a good Thanksgiving. Bye. Love y'all.